So now that we know the facts of the situation when Ann Taylor was appointed to represent Bryan Kohberger, it's time to take a look at the law of conflicts of interest. We got a lot to cover here, so let's get right into it. The first place we need to look for any question about conflicts of interest is the professional rules that tell us what a conflict is. In Idaho, that's going to be RPC 1.7. So we're going to take a look at that rule. We're going to break down the different pieces of it, and then we're going to take a look at some of the cases that have applied this rule in different settings to give us a sense of how it might apply in this particular situation. So RPC 1.7 tells us a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. It's disqualifying, is what this rule is telling us. You shall not represent the client if there is a concurrent conflict of interest. So what does that mean? A concurrent conflict of interest exists if 1. The representation of one client will be directly adverse to another client, or 2. There is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by the personal interests of the lawyer, including family and domestic relationships. So let's take these one by one: directly adverse and materially limited. We're going to start with directly adverse. The interests of one client are directly adverse to the interests of another client when they are on opposite sides of a material issue. Now, the most obvious way that this happens is if you have one client that sues another client. They are sitting at opposite tables, they are fighting over liability. One of them is going to be right and one of them is going to be wrong. So that is a situation where clearly a lawyer is not going to be able to adequately fight for both of them to win because they can't both win. So in that situation, that simultaneous representation is clearly prohibited under the rule. But there are other situations besides just that direct head-to-head type of conflict that would qualify as directly adverse under RPC 1.7. A common situation where we see this in the criminal context is when you're dealing with co-defendants. And in fact, a lot of the Supreme Court case law that deals with conflicts of interest in the Sixth Amendment context is looking specifically at a situation where you have one attorney who is representing multiple co-defendants. A third situation where this can come up that is actually contemplated in some of the comments to the Idaho rule is in a situation where the attorney is representing both the defendant and a state witness. Now, an important thing to bear in mind is that in the first situation, one client suing another client, you have an actual conflict at that point, because for that dispute to be able to be resolved, those interests, those conflicting interests are going to have to be sorted out. But with co-defendants and with witnesses, you don't necessarily have a conflict at that point in time. It's a potential conflict. And so then what the case law on that subject tells us is the difference between when is representing a defendant and a state witness actually creating a conflict of interest versus when does it just have the potential to do that. So it's an important distinction that we're going to take a look at the cases to help us sort out. The first U.S. Supreme Court case to look at this issue was Glasser. And Glasser was a 1942 case in which a single attorney was appointed to represent multiple co-defendants in a single trial. And in Glasser, what happened is the court recognized that the attorney was in a position where, depending on which client's interest the attorney wanted to serve, would drive the strategy of cross-examination of a particular witness. And in that particular case, the court found the attorney basically went easy on this witness because it served the interests of one of his clients at the expense of one of the other clients. So in that situation, you had a clear adverse set of interests there between those clients that the attorney can't adequately serve both of them. So Glasser recognizes when that type of situation materializes, you actually have to choose between, am I going to benefit this client or this other client? You have a conflict of interest that is a problem. But an interesting point from Glasser that's also carried on in later opinions of the U.S. Supreme Court is that that doesn't mean that it's automatically a problem to represent co-defendants in a single trial. In fact, the court recognizes sometimes there is an advantage to doing it that way. In a dissenting opinion, Justice Frankfurter said, joint representation is a means of ensuring against reciprocal recrimination. A common defense often gives strength against a common attack. This came up in a subsequent U.S. Supreme Court decision called Holloway, which again dealt with simultaneous representation of co-defendants in a single trial. And in that particular case, the attorney was in a position where all of the co-defendants wanted to testify, and he was not going to be able to cross-examine them because he had received confidential information from each one of them. And so to be able to protect one co-defendant, you would, under that circumstance, need to be able to cross-examine the other co-defendants when they give inconsistent explanations or, accounts of what actually transpired. So the Holloway court recognized and adopted that dissenting viewpoint from Justice Frankfurter, but at the same time, it recognized that when it does boil down to a situation where you're going to have to throw one client under the bus in order to protect your other client, that is where you do have an actual conflict of interest and where that joint representation is going to be prohibited. So that gives us a little bit of a outline, an overview of the difference between when a conflict of interest is potential. It could turn into something problematic, but it could also be perfectly fine if both of the co-defendants have the same version of events, they have the same strategy, there's nothing that the attorney is going to need to do that would, sacrifice one for the benefit of the other, then joint representation in that situation is fine. It's only if the attorney is going to have to pick one or the other that turns into an actual disqualifying conflict of interest. What we get from these U.S. Supreme Court cases is simply the recognition that if you only have a potential conflict of interest, your client's interests are not directly adverse. So it wouldn't constitute a disqualifying conflict under the first part of Rule 1.7. But in many ways, these are kinds of hypothetical situations, of course, because we're not dealing with co-defendants in this particular case. We're dealing with a situation where Cara Kernodle is charged in separate cases with separate legal matters, and at most she has the potential to be a witness against Bryan Kohberger. The most likely way that she's going to become a witness, as we talked about, is because she's going to have a right to testify at sentencing should the case get to that point. But we don't have any reason to believe at this point in time that she is a witness on any material fact that relates to Bryan Kohberger's potential culpability. So what does that mean, and how does that situation work when you're dealing with representation of a defendant and a potential witness? Well, we got cases on that too, so let's take a look at a couple of those. The first case we're going to look at here is called Dye out of the Idaho Court of Appeals. And so in Dye, what happened, you had public defenders representing a gentleman at trial, and once the trial is underway, the state identifies a surprise witness, a jailhouse informant who's come forward. And as it turns out, these public defenders have also represented that jailhouse informant in an unrelated extradition matter. So the defendant argued that this constituted a conflict of interest, and the Idaho Court of Appeals rejected that argument. It concluded that Any impeachment of this witness would be done on the basis of information that was already in the public record, not information that they received confidentially through private attorney-client conversations with this informant. It also concluded that because these matters were unrelated, that there was no direct adversity between the interests of the informant, that the public defender would be able to represent those while also being able to represent the interests of the defendant in the Dye case. Because it wasn't a situation where you would have to pick one to further the other, they can both be accommodated. And lastly, in Dye, the court had relieved the public defender's office of the responsibility for further representation of the jailhouse informant in order to prevent a new conflict from materializing at some point. So this situation shows us, number one, conflicts do emerge at the last minute. These are things that courts are pretty accustomed to dealing with. Public defenders represent nearly everybody in the system, so pretty good chance if you're going to bring in a jailhouse informant that, yeah, that person is going to have a public defender representation. It's just statistically likely to be the case. But it also shows us that the fact that you represent people in unrelated matters in and of itself, that doesn't make their interests adverse. And in fact, impeaching the witness that you have previously represented doesn't necessarily make those interests adverse as well. If you can do that without revealing any confidential information that client has disclosed to you, then there is no problem under that circumstance. And so in Dye, it was held not a problem. The conviction is going to stand. Another case addressing this situation that often comes up with public defender offices is Cook. And in Cook, the situation was the same public defender's office, incidentally, the Kootenai County Public Defender's Office, simultaneously represented the defendant in a case that involved various different charges, the alleged victim of the rape with which the defendant was accused, and also 4 out of 5 state informants who were going to be witnesses on other charges. The Cook case looked at this situation pretty closely, and it evaluated the likelihood of a conflict arising when the same attorney is representing both the defendant and a potential state witness. And it recognized that when the witness is on the opposite side of the defendant's culpability, which is almost always, but not always, going to be the case with state witnesses, then that is likely to create a conflict of interest type of situation. However, because the particular attorney who represented the defendant in that case was not the same attorney that represented all of the other witnesses, it was other defenders in the same office who did that. The court held that that conflict does not get imputed to the entire public defender's office. There is a rule when you're dealing with private law firms in Idaho that one attorney's conflict is treated as the conflict of the entire firm. And so if one attorney is disqualified, the entire firm is going to be disqualified. But the Cook court recognized that public defenders' offices are different. They're not financially invested in their clients the way that private attorneys are. So they don't have any incentive to have this situation where you want to, make one client happy, again, throw another client under the bus in order to save the more valuable client. It's just a situation where you get appointed multiple cases and you don't particularly care, which one you get or don't get. So you don't have the same types of interests in furthering your client's position at the expense of other clients that an attorney in private practice might have. So Cook basically held that even if this was a conflict of interest or would have been a conflict of interest had it all been the same attorney. Because it was different attorneys in the public defender's office, that conflict did not impute. And that rule has also been upheld by the Idaho Supreme Court in a later case called Severson. The last case that we're going to look at here is an Idaho Supreme Court case called State versus Araiza. So in Araiza, a defense attorney in a capital case moved to withdraw from representation because he had previously represented one of the state's witnesses. And that witness had informed a defense investigator that he had lied under oath in his own trial. And so based on this, the attorney argued he would be required to use this information he had obtained in the course of that representation to impeach the witness's credibility on the stand. And so that would create a situation where he was using that confidentially obtained information to the detriment of his former client. There was also a second motion to withdraw that was made later on in the trial on the basis that this attorney also represented at the same time another one of the state's witnesses on their list. So the Araiza court held that neither of these things constituted an actual conflict of interest. With respect to the first witness, because he had used the information about his prior perjury in his own post-conviction proceedings, that information was no longer confidential. It was available in the public record, and so that impeachment did not require the attorney to rely on confidentially obtained information. Second, because the defendant had argued that his attorney's ability to cross-examine the former client was impeded by his ethical duties, the court rejected this argument because it had not allowed the attorney to cross-examine the witness about this prior act of perjury, because that's not allowed under the rules of evidence. That's not how you impeach somebody for problems with their credibility. So with respect to that particular witness, there was no problem, no conflict that actually materialized in the course of the representation. With respect to the second witness, the state elected not to call that witness. By not calling that witness, no adverse interest was presented. There was no actual conflict that actually materialized. So in the Araiza case, again, the convictions were upheld despite the existence of apparent potential conflicts by the public defender representing the defendant. So what are the takeaways from these cases, and how do they relate to the Kohberger situation that we're dealing with here? Well, so from Glasser and Holloway, the U.S. Supreme Court cases, we get the principle that potential conflicts of interest are fine. They're not a problem. What's a problem is when that potential conflict ripens into an actual situation where one client's interests are in direct opposition to the interests of another client, so that you can't adequately serve both of those interests. We learned from Dye that previously representing a state witness on an unrelated matter does not in and of itself create an inherent conflict of interest. So the fact that Ann Taylor had previously been counsel of record for Cara Kernodle at the time that she was appointed to represent Bryan Kohberger on December the 30th was not a problem. That doesn't create an actual conflict of interest. It creates at best a potential conflict of interest based on the possibility that Cara Kernodle could end up being a witness in some way in the case. We learned from Dye and Araiza that impeaching your former client with matters that are already in the public record, such as impeachable prior convictions, things of that nature, that does not create a conflict of interest because those aren't confidential information anymore. Once it's in the public record, even if it was initially confidential, by disclosing it in the course of the representation in Araiza, that eliminates the confidentiality of that particular communication. So that can be used, and that in and of itself, again, does not create a conflict of interest. We also see from Dye that these conflicts of interest can be managed. It is okay for a court to say, you know what, to avoid this being a situation where you are actually at the same time representing the same people, we are going to relieve you from the future representation of one of your current clients so that that current client now becomes a former client, and you don't have to worry about a situation where a current client is being, cross-examined by you and perhaps legitimately questioning whether you are an appropriate advocate for that person because you're having to take an opposite side of an issue from them and potentially raise issues that could make them look bad. We do know from Cook that that situation, cross-examining your current client on an issue that is materially adverse to your, defendant in your case, that is likely to present a conflict of interest. So in a situation where Ann Taylor, say she stayed on representing Cara Kernodle, and then Cara Kernodle is a witness at trial on an issue dealing with Bryan Kohberger's culpability, then that is going to be a potential conflict of interest. But we've learned it wouldn't disqualify the entire public defender's office. You can simply bring in another attorney to be able to handle that part of the representation. But because Ann Taylor withdrew from representing Cara Kernodle on January the 5th, she's no longer a current client of Ann Taylor's. So to the extent that there is an inherent problem with cross-examining your current client, that problem has been resolved by the actions that the parties took in this case, by making sure Ann Taylor is not going to be formally counsel of record for both of them under the circumstances of the case. So we spent a lot of time in this video talking about what it means for clients' interests to be directly adverse within the meaning of RPC 1.7. And so in the next video, we're going to turn to that second section of RPC 1.7, and we're going to be looking at what it means for there to be a significant risk that the attorney's representation is going to be materially limited by some other duties. Join me there.